is now in session. The Honorable Brian D. Lambert, Judge presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Slipped that judge thing in there, didn't you? Honorable Brian D. Lambert, custodian presiding. Okay, good morning. Welcome to another session of oral argument before the 5th District Court of Appeal. It is Tuesday, February 24, 2026, and as just announced by our marshal, I'm Brian Lambert. I'll be presiding over the cases this morning for the court. Let me introduce the other panel members. To my right and your left is Judge John Harris, one of our legacy judges here. His dad used to be on the court long ago. In fact, I'm in his office now. Not his office, his dad's office. And to my left is Judge Adrian Soud, legacy in another fashion. His father was a long-time esteemed trial judge up in Jacksonville. So we're here today. Two cases. The first case is 24-3394, Margaret Duckworth versus William C. Cornwell and True-Vine Landscaping. A couple things. Each side will have 20 minutes to argue. I will leave a default time of 5 minutes for a rebuttal for the appellant. If you would like a different amount of time, please let me know, and the marshal will set the clock accordingly. When you get into your rebuttal time, you will see the yellow light go on the podium there. That doesn't mean you have to immediately stop. You can continue on, or you can stop earlier than the 5 minutes if you choose. You do not get an aggregate total of more than 20 minutes. So if for some reason you talk for 20 minutes in your initial argument, then you won't have a rebuttal. A couple other things. We are being live streamed because we have an audience of millions that watches our oral arguments. So if you have an electronic device, please either mute it or turn it off so it doesn't distract either your opposing counsel or the court. That being said, I don't have any other preliminary comments to make that I can think of at this point. So without further ado, first case, Mr. Butler. You're Mr. Butler, okay? Would you like 5 minutes or some different amount of time for rebuttal?
I would like to reserve 5 minutes, please, Your Honor.
Very well. Thank you, counsel. All right, if you're ready, you may proceed, sir.
And thank you, Your Honor. May it please the court. I'm Todd Butler. I'm for the appellate here. And this case presents, this case presents a straightforward question. When a plaintiff testifies that she felt something tough and hard catch her foot, that it caused her to spiral out, and then when she looked back and she saw from where she fell, she saw that there was a sprinkler head standing up there, and there was only a sprinkler head standing up there, and nothing else there that she might have tripped over. Does she also have to prove why the sprinkler head was up in order to show a jury that the sprinkler head is in fact what caused her?
Well, let's get past some preliminary discussions either in the trial court level or in your opposing counsel. I'm assuming she tripped over the sprinkler head. So we don't have to talk about did she or didn't she. So she tripped over a sprinkler head. All right, but I mean, you agree that simply because there may be an accident, that doesn't equate to negligence. This is not a strict liability scenario.
Certainly not, Your Honor, but the trial judge did find that there is sufficient evidence to establish negligence through the breach of contract, a contract that was intended for Mr. Cornwell to examine or to inspect the premises and to repair or conduct the maintenance operations there. So the trial court has found that that there is negligence there. But yes, you are absolutely right about that. The fact that she fell does not necessarily mean is completely independent from whether there was any negligence at all.
Well, what evidence is there in the record of negligence?
Well,
I mean, to me, I'll give you the lead in so you can maybe answer it more precisely for me. Okay, assuming the sprinkler head's up and it's not supposed to be up, and your client tripped over it, why does that mean that it was caused by the defendant?
Because Mr. Cornwell had a contractual obligation to inspect and repair the sprinkler system.
But he's not on the site every day, is he?
He's supposed to conduct the inspections, and he's supposed to conduct them with frequency enough that these things are found. And he said in his deposition testimony, he said that on a regular basis, he replaces one or two of these sprinkler heads every time he inspects.
Okay, but I have a guy that does my sprinkler heads too. I mean, so if one comes up, that means it's his fault and he should know about it and he needs to come out. Assuming one thing if I tell him, hey, come out and fix the sprinkler head, but if he isn't aware of it and it happens in between his visits to my house, why is he the one who's somehow responsible for the fall?
Well, because if he's got a contractual obligation to inspect and repair the sprinkler heads, and he does not conduct the inspections, that is also part of the evidence. He did not conduct the inspections.
So he would come out there. How is he not conducting inspections if he's coming out there and he says he replaces one or two every time he visits? He must be inspecting something to decide that they're broken, and he fixes it, right?
He testified that he had not performed the inspection within the time span that it was supposed to be performed. He had not conducted the inspection, and that is a matter of record.
Well, what if the sprinkler head came up 30 minutes before your client fell?
There's no evidence of that.
I know that. I'm asking you, what if? That's the point of this, to me, the whole case here.
I've got to look at it from the point of view of the law.
Look at it at the point of view of what's my question I'm asking you, and what do you want to answer?
Well,
how about that?
If it popped up magically 30 seconds before she walked,
they come up. It's not. If I see a sprinkler head in my yard that's up, I don't think that some magic happened. I assume something has caused it to come up, whether it's a neighbor kid playing around, or it went up and it didn't come down when the sprinkler stopped working. The water stopped working.
They come up when you put water pressure on them.
Yeah, right.
They come up when you put water pressure on them.
Sometimes might not go down, right?
And they may not go down because they've got one of the points that the trial court said was they can go back down, or they can come up and they can stay up because of dirt. Well, that dirt would be something that Mr. Cornwell is supposed to be looking for.
But getting back to 30 minutes. Let's say this happened 30 minutes before your client fell. Under that scenario, would the defendant be liable? Would this defendant be liable?
Your Honor, there's no evidence for that, though. If it came up 30...
Counsel, I get to ask questions. I get the record's the record.
Okay.
We all understand that. I'm trying to find out this concept of yours. You're agreeing it's not a strict liability scenario, okay, and you agree with the principle that simply because there's a fall, that does not mean it's negligence, because then would in essence be a strict liability scenario. But I don't know that if you agree or disagree that there has to be some amount of time frame for someone to become who's obligated, if you want to use the term contractually, because that seems to be the buzzword today. If they're contractually obligated to fix these things, they need to become aware that there is a problem, right?
They do, yes.
Oh, okay. So again, don't have to tell me it's not the evidence. I want to understand my hypothetical, the question of my hypothetical. If it's 30 minutes, if it's 10 minutes, that does, if it came up 10 minutes before your lady fell.
If they've got evidence that came up 30 minutes or 10 minutes before they fell.
It's my evidence right now, counsel. That's it.
They do. Then yes, I would say that okay.
You would concede that your client has an unfortunate accident, but that doesn't equate to liability of the landscaper.
It would. But if I could follow on that, then that water sprinkler came up the last time there was water pressure on that sprinkler head. Unless, and again, there's no evidence of vandalism, but unless some vandal came and pulled it up. But the last time that sprinkler came up, when the last time water pressure was put on it, and the last time water pressure was put on it was outside the time frame when Mr. Cornwell was supposed to inspect. If Mr. Cornwell had inspected, then if he would have inspected after the last time water pressure was put on that sprinkler head, then he would have found that sprinkler head, and like he said, when he found them up like that, he replaced them. So that would have been the outcome. That would have been what happened if that had been the case. Now, if for some reason or another it had come up, like you're asking, 30 minutes, 10 minutes before, the day before.
Well, let me ask.
Sure.
Let me ask it a different way. We'll see if we could change course here, and I can get clearer with either my questions or my understanding here. Didn't your lady testify? She was visiting her daughter, right?
She's visiting her daughter, yes.
She visits her daughter, did she say daily? Did she testify
Daily, and she walks right through this path frequently, yes.
Okay, so every day she's walking by this area that has a sprinkler head, and she doesn't notice that sprinkler head being up until the day she falls, she looks back and sees it up. I mean, isn't that suggestive that it wasn't up the day before?
Not necessarily.
No. So she walks right by. If I understood, it was kind of a narrow area. She wasn't walking, a 48-foot wide, expressway or something like that. She's walking right by the same area. Doesn't see it. Doesn't trip over it. Doesn't say anything to anybody about, hey, that sprinkler head's up. It's dangerous. Right? Is that in the record?
It sounds like a great argument for the jury, but yes, she goes through.
It's not. Isn't that what she said?
Yes, she
scenario?
did. She did.
Okay, so she's walking by it but I mean, it gets to the point of when we're going back to you didn't like my 30-minute scenario here
okay.
for whatever reason. Okay, but so your lady is walked the day before she's by there. Apparently nothing there. No extended sprinkler head.
There was nothing seen there, and her foot didn't contact there. Now, we're talking about a small space, but we're also talking about a very small sprinkler head. Just because her foot passes over that corner area, that bare corner area there between where it comes through, it's got to pass through at exactly the spot where that sprinkler head is. Now, the pictures, probably the best, I don't know if y'all have got the color pictures or not, but there are some color pictures in the plaintiff's first brief in opposition to the summary judgment in the trial level. There's pretty good color pictures in that if you've got the color pictures, but you can see how tight an area it is. Her foot could still nevertheless pass through and pass over that without actually contacting it. The way the eyes work, I mean, you've dealt with...
so it's hard to see.
It's hard to see, yes, exactly. It's very hard to see.
Okay.
And the foot could pass by it without seeing it. And the first time she did see it was when she saw it with her foot. When her foot...
No, she'd been by it day after day after day after day before. According to her testimony.
I don't disagree.
I know you don't like the way you think I'm swinging this.
I'm not disagreeing.
That's what she says.
I'm not disagreeing with that. I'm not disagreeing with that. But I am... I think it can also just as easily be said that she could walk through that without hitting it. I mean, it is possible for her foot to pass by that without her ever hitting it. And then on the day when it did hit it, that was the day that she fell. And that it could be completely unseen and nobody would notice it standing up there or she would not notice it standing up there until she was passing by on that particular day. I mean, it's a very, I mean, what you mentioned that you've got the sprinkler heads in your own yard. I mean, the diameter of them is probably 2.5, 3 inches at most, probably not that. I mean, it's not a large object standing up there in the middle of the.
I know. I mean, not necessarily equating to me, but I mean, if you walk into my front door, there's a sprinkler head right by the sidewalk there, and I would see it. It's not a big thing, but if it was up as opposed to not, it would be seen. I mean, I get factual issues. I get summary judgment. I get all the standards, and in fact, him and me were the people on the opinion that caused the summary judgment rule in Florida to change. So I get all that. You know? Used to be the slightest doubt and something was in the air or something like that. Harris didn't like it, so we changed it or something like that.
And that has changed now. Yes.
Yeah, I know.
Yeah. So. Sure, where we want to...
This is not an actual knowledge case, right?
An actual...
You're not saying that he knew that the sprinkler was up?
No, he should have known. Yes, sir, he should have known.
Constructive knowledge.
Should
have known is based on time.
He should have known based on his contractual obligation to perform the inspection.
Based on the amount of time that the unsafe condition existed?
He's supposed to inspect in an amount of time as prescribed by the contract, and if he had inspected within the amount of time as prescribed by that contract. And this has been our contention. Of course, we've got to prove this. We've got to convince the jury of this, that if he had, even though the trial court found that there is sufficient evidence for the jury to decide, the trial court did find that, and there was no cross appeal on that. The trial court did find that there was sufficient evidence for the jury to find negligence there based on the breach of a contractual obligation that created a situation of hazard. If he had inspected within that time, our contention is going to be
He
that
should have known of the unsafe condition
Should
because
have
he
known.
didn't inspect.
he did not conduct his inspection within the period that he was supposed to conduct the
What's the period
inspection.
he was supposed to conduct?
A month. He was supposed to inspect it on a monthly basis. Now, is that in itself a sufficient amount of time to go around and inspect those? It depends on how many times a month those sprinklers run. I would think he needs to inspect it every time after, but that's a different contention or a negligent drafting of the contract that would come up. But that would be that's not something that's ever even been reached yet. But the monthly period that he was supposed to inspect, if he had inspected it during that period, he would have found it. And again, I would emphasize again that the trial court did in fact find that there was sufficient evidence to take that question to the jury.
Then why did the judge grant the motion?
He failed to recognize or failed to pay attention to the fact that these are two completely independent inquiries. The fact that the fact that she tripped over the sprinkler head, and I think you said that you're sufficiently convinced that that's there. I mean, there's really not an alternative to what she tripped
fell and
over.
she turned and said, "I tripped over the sprinkler head," or something to that effect.
She saw it. There was nothing else
I
there.
don't know what inference that he. But I don't know.
So there was nothing else there for her to have tripped over. So he. The trial court, well, I don't know, I'm a little
He
bit,
tripped over something, and the trial judge found that the defendant was negligent, but still he was granted summary judgment.
well, correctly, those are two separate inquiries, though. You don't have to prove negligence in order to prove the fact that she tripped over the sprinkler head by the same fact that the fact that she tripped over the sprinkler head, that could have happened and there could be no negligence at all. Both of those could be the case.
Right.
There could be no negligence, even though she tripped over the sprinkler head. She could have tripped over the sprinkler head even, but the trial court judge said that these inferences are stacked, and they're not stacked. These inferences are too complete. They both rely on the same evidentiary, the same established evidentiary fact that the sprinkler head was up at the end of the, after she failed, after she looked back, she saw that the sprinkler head was up, and because the sprinkler head was up, that's not conjectural, that's not speculative. Both lines of inquiry are based on that fact that the sprinkler head was up, but they're independent of each other. They don't rely on each other, so they're not stacked inferences.
Counsel,
And Your Honor, I'm
you're
past.
into your rebuttal time.
I am. Yeah, I'm getting into rebuttal time. So, Thank you, Your Honor.
All right, you got 3:52 on rebuttal. All right, counsel?
Thank you, Your Honor. I'm recovering from a cold. I'm going to keep my water near if that's okay.
No problem.
Counsel, Mr. Clerk, Judge Lambert.
The marshal over there, but actually.
I'm sorry?
That's the marshal over there.
Marshall, I'm sorry.
There you go.
Mr. Judge Lambert, Judge Harrison, and I want to take a moment to acknowledge of my time briefly that I have the distinct pleasure of now having oral arguments in front of Judge Soud, in which I've also had the occasion to try a premises liability case in front of him. That hasn't happened in my
Still coming
career.
back for more, right?
And it may not happen again. We'll see if it's
Still
a
coming
pleasure.
back for more. Here we go. You better man than us.
We'll see if it's a pleasure once we're done with questioning, of course. But Good to see you all again. May it please the court.
Yes, sir.
Here on summary judgment, of course, asking the court to uphold summary judgment that was granted in favor of my clients, the appellees, Mr. William Cornwell and his company, Truvine Landscaping. The court correctly found that there's no causal connection between what appellees did that caused appellant's fall. And that's because you can't do that without speculating or conjecturing as to what caused the sprinkler head to be extended.
Just so I'm clear, it's not your argument that she didn't fall over the sprinkler head, is it?
It is a part of the argument, Your Honor.
That's not your best argument, is it?
It's not the best argument, no. But it is a part of the argument. It's one that the trial court found. I do want to at the outset
Didn't
note.
she fall and she turned and she said, I tripped over the sprinkler head?
She didn't say that, and that's actually an interesting point. She was very equivocal on that. Many times she was asked during her deposition, what happened? What'd you trip? What'd you fall over? And she went about it excluding certain things that it might have been, but her testimony was something caught my foot. Repeatedly she was asked, and repeatedly she answered, something caught my foot. Now, Your Honor is correct that it's a reasonable inference, maybe even the best inference, that she tripped over the sprinkler head.
Was there something else around there that she would have tripped over?
The very reason she claimed she cut across the sidewalk or cut across the flower bed as opposed to using the sidewalk would be one of those reasons. She said it was an area that was bushy, that contained mulch, and it made it difficult for her to walk up the driveway and on the sidewalk. Had she done that, she would have avoided the sprinkler head completely. But the importance of the question there is because that is what the trial court didn't find that there was negligence because of the extended sprinkler head. What the trial court found is you could make an inference that appellees were negligent because of the extended sprinkler head, but there's other reasonable inferences that could be drawn from the...
But I guess I was somewhat at a loss as to what the big discussion about inferences were from the trial judge. I mean, to me, and I think Judge Harris is pointing this out, okay, this is not an actual notice. Your client was not aware of this sprinkler head being up. So for him to have any liability, wouldn't it have to be some constructive notice that his duty is to fix these things? He should have been aware of the problem, for lack of a better term, and he didn't remedy it in sufficient enough time to prevent Ms. Duckworth from falling. Isn't that what this case is about?
It is, Your Honor, and it would be...
Isn't that what the case should be about, if that's not
and
the right
it would be, and by way of a bit of background, of course, it's clear from the record, Truvine was not the property owner. This was an apartment complex.
I mean, to me, it's a different scenario. I mean, going back to Lambert world of sprinkler heads on his property, if I'm aware of it, then I as the property owner have a duty to make sure my property is in a reasonably safe condition. I don't know that I have one duty, and certainly I have a sprinkler guy, if you want to use that term, that comes and fixes the sprinkler heads when we let them know, or they come out and check these things. But they don't have omnipotent knowledge of all problems with my sprinklers at any given time. So it's one thing for me to be potentially liable because I'm not correcting a alleged defective condition of my property, but the sprinkler guy who may do other work for lots of other people, that's where I'm kind of missing the plainest view of this case.
That's right, Judge.
And the stacking of inferences there was no need to stack anything about anything. It was a matter of can you prove that this person knew of the condition a reasonable enough time that he should have fixed it pursuant to his contractual obligation of the property owner. Isn't that this case?
Yes, Judge, and summary judgment could stand on either. The key, and that's what, I know it didn't come up in the appellant's presentation, but to be clear, under the new summary judgment rule, improper inference stacking is still correct law. And when you look at some of the federal cases that talk about transitory substances, that's where this often comes up the most. And you're looking for something to show constructive notice. You're looking for the defective condition. That would be liquids, waters. That's what you see most of the time.
There's an actual statute in Florida on that.
There is, absolutely. And it can be instructive here because it goes to that constructive knowledge element. You're looking for something plus the defective condition, something that would indicate that it had been there for a long enough period of time. And what those cases often talk about are things that do show that it had been there for a long period of time, but also other reasonable inferences that can be drawn that would suggest it had not been there for a sufficient period of time. And that's why at the trial court level, the judge, we believe, honed in on the stacking of inferences, because Ms. Duckworth she was very equivocal on what caused her to fall. Perhaps because it's hard to see, per her own testimony. Perhaps because if it was
trying to be extremely honest, saying, I wasn't looking at that. I tripped,
Right.
so I looked, and I was trying to figure out what caused it. Maybe this, maybe that, but oh, by the way, there's something sticking up there, and boy, that's probably it.
Right.
I mean, that seems a perfectly reasonable testimony to have been provided. If you're trying to figure out why you fall, you just don't fall for no reason usually, unless you get old like me and Harris or something.
Sure, and of course there's other the sprinkler head being in an extended position post fall. That's an important fact here, because it could have been extended before the fall. That doesn't inform us in any way as to how long it was extended before that.
Well, it was extended before the fall. It's just a matter of how long it was extended. It popped up 2 minutes before Ms. Duckworth came by. Hard to say that becomes hard to make your client liable for that scenario.
Sure, any amount of time before the last inspection, which is the only reason that Truvine would be there, is because of its contractual obligations with the association, the property owner, or the property manager. It's not. They are there to do lawn maintenance services, and part of those lawn maintenance services would be replacing defective sprinkler heads. So there would be zero notice unless it was there before, at the time of the last inspection. Or skipped. But
what is their contractual duty? Okay, is it simply we go out there and there's nothing sticking up, off we go, we're good day, or do they have to run the system and see if the sprinkler heads come up, see if they work correctly, see if they go back down, and if they don't, then there might be an issue as to why sprinkler A, B, or C is not going down? Isn't that part of their contractual duty, I assume?
It's unclear from the contract. It's garden variety lawn maintenance services, clipping, cutting, right, pun intended, I suppose. Clipping, cutting, those kind of things, but it also involves replacing sprinkler heads that don't work.
Well, sure. I mean, if it doesn't work, but I mean, you have to, part of their duty is, they have to replace the sprinkler heads that don't work. They have to figure out if they're not working, if they're all still, if they're level with the ground and they don't come up when you turn the water on, then they're probably not working. That's not very useful sprinkler if it doesn't sprinkle.
Or if you get a report from someone, the association, the property owner,
But you don't have a
the
report
manager.
here, which inures to your benefit in the context of what happened below. You don't have a report that there's some problem. But that being said, your client's tasked to go out there to make sure the system is operational. I assume that's what the purpose of the contract is, right?
Sure.
All right, so they go out there and they don't just say, well, all the sprinkler heads are level with the ground, we'll see you next month. Do they check to see if they work? Sprinklers come up, they spray instead of just going straight up with water flowing out. They actually spray around, and then when the water is done, after 30 minutes or whatever the time frame, then they come down, because you want them to come down, you want them to stick up. So you avoid people like Ms. Duckworth perhaps falling, or anybody falling over, right?
Which is why the trial court said an extended sprinkler head could be evidence of negligence. Didn't say it was. Didn't rule that it was evidence
Well,
of negligence.
your opposing counsel seems to say the trial court found there was negligence by your client.
The trial court said in paragraph E of the order granting summary judgment, taken in the light most favorable to plaintiff, a jury could infer from that circumstance, the circumstance being an extended sprinkler head pre-fall, that defendants were negligent in the performance of their contractual obligation. But the court goes on to say in paragraph H, which is where the stacking of inferences analysis comes up, but defendant's negligence is not the only reasonable inference that can be drawn from the circumstance of the extended sprinkler head. Meaning it could be...
Is he supposed to construe it favorably towards the non-moving party?
Sure, and you cannot, absolutely, and that is done for that to be stacked on another inference. And really, there's three total inferences. There's that the extended sprinkler head is extended because of negligence of the defendant, as opposed to other causes, such as someone pulling it up, someone manipulating it, dirt getting stuck in it, whatever it may be. It would also go to whether it was extended or not pre-fall. You cannot exclude the potential that the appellant tripped over a flush sprinkler head and during the fall pulled the sprinkler head up with her shoe. That's certainly an inference that that could be drawn from the evidence in the case. And then the third inference, of course, is that she tripped over the extended sprinkler head as opposed to her own feet, something else, branch, mulch, what have you. But all of those things don't prove what still has to be proven, which is that to tie negligence for a pre-fall extended sprinkler head to the appellees, you have to show that it was there for long enough for the appellees to be on notice of it being there. And there's no record evidence of anyone reporting any issues with this particular sprinkler head. In fact, as Your Honor pointed out, which is something we were going to raise, Miss Duckworth herself visited her daughter daily. She worked, I believe, at the school board, and so in the summer, while kids and others are off, she's not. She's working, but on her lunch break would come daily or near daily to her daughter and would take the same path. She testified, I took this path because of shrubbery and things that prevented me from walking reasonably, cars parked and things like that, to stay on the driveway and stay on the sidewalk, the designated course. So there's just simply no evidence in the record that this existed for a long enough time for the landscaper, the appellees, to be on notice of it and to correct it. The other issue I talked about very briefly, under the new summary judgment rule. I don't think I realized that Your Honors were a part of that. But of course, that change did not remove the inference stacking. We've had cases, in fact, a case from this court, the Leftwich case, where I know Your Honor was in dissent, Judge Stout, but not in dissent on the application of the inference stacking rule. That's still something that can be applied in Florida under the new summary judgment standard. And then one thing to address that hasn't been addressed too, just out of caution, is there was some, so the kind of procedural unfolding of events was that summary judgment depositions happened, summary judgment was made, there was a hearing, and then summary judgment was granted. I believe summary judgment raised in January of 24, granted by May of 24. Final summary judgment wasn't entered for quite a while. There was a motion for rehearing filed, and as a part of that, some additional evidence, an affidavit, two affidavits were submitted, and those affidavits, the trial court correctly excluded those because they were not new evidence. They were presented after summary judgment had already been ruled on, and they were affidavits from the appellant's husband and the appellant's daughter, the one she was visiting at the time of the incident, and that was not new evidence. It was evidence that could have been submitted in opposition to summary judgment months earlier, and it was not. But even if it had been considered by the court, it still didn't establish anything other than what Ms. Duckworth herself already testified to, which is that after she fell, after something caught her foot, she looked back and saw the extended sprinkler head where she had just walked. So those were properly excluded. So, and I know I have some time left, but
Your daughter's affidavit, she didn't say that after the fall she saw the sprinkler head up. I thought in her affidavit, the one that was excluded, she said she actually saw her mom trip over the sprinkler.
I believe, Your Honor, well, I could be corrected on that.
Maybe I'm remembering that wrong.
I believe that she saw of course the record would speak for itself, but I believe that what she said is, Mom, you tripped over the sprinkler head, and she's seeing the sprinkler head extended post-fall. But even if she testified that she saw the sprinkler head extended pre-fall, it still does not establish that the sprinkler head was extended because of appellee's negligence. There are still other potential things that could have been the cause of the sprinkler head extended. So it's not enough. It doesn't give us that plus. An extended sprinkler head could be a defective condition, but then what's the additional evidence that would suggest that there's constructive notice of it? And that's completely devoid from the record. And under the summary judgment rule, the new summary judgment rule here, the appellant at trial as the plaintiff would have the burden of proving that constructive notice, and that's simply lacking here. So And again, I know I'm leaving some time on the table, but that's certainly okay.
You're not required to use all your time.
Of course, and nor should you if you've made your points or feel that you have. An older lawyer taught me when I was younger in my career.
I'm not trying to dissuade you from using. I'm just saying you're not hurting anybody's feelings if you stop.
No, of course. And so under improper inference stacking, lack of constructive notice, summary judgment was properly granted, and we ask that the trial court's decision be affirmed on appeal. Thank you.
All right, thank you.
Your Honors, I will try to move quickly here.
You got 350. You move.
Yep.
whatever
First of
pace
all,
you want.
the question on the excited utterance, he did mention that the affidavit was submitted after at the time of the rehearing. The excited utterance was discussed at the hearing on the motion for summary judgment. That is in the record at my number is R2370. That is the hearing transcript on page 31. So the question of whether the daughter's excited utterance was actually put in front of the court for the purposes of the motion for summary judgment, that did happen during the hearing on the motion for summary judgment. The evidence of the fall, there's tactile, visual, and elimination evidence. She felt something tough and hard pull her foot. She turned around and looked, and she saw the sprinkler head up. And the elimination evidence, she saw nothing else there. So I think that the fact of the fact that she fell because she tripped over the sprinkler head is excluded is established to the exclusion of any other reasonable inference. The decision, and Judge Lambert, this is something that you were pointing out, the analysis of cause and fact and the analysis of negligence are two separate analyses. One does not depend on the other. You can fall without somebody else's negligence. You could have negligence, and somebody could have found it and said, oh, that's up, that needs to be down. And somebody could have found that before somebody fell. There could have been negligence without an injury. Now, the question that seemed to be that y'all were most interested in from me was whether there's evidence of whether the trial court was correct. And here I feel like I'm defending the decision that went against me, but was the trial court correct in saying there's sufficient evidence? And again, the question is sufficiency of the evidence, not whether we've proved the fact to the exclusion of anything else, but whether we've got sufficient evidence to go to the court, to go to the jury on the question of the negligence. I would say the trial court quoted Clay Electric or cited Clay Electric, and I don't have the citation right there, but it's in the order. Clay Electric 87. It's a 2023 Supreme Court case. This case is point on point with Clay Electric. In Clay Electric Cooperative was the undertaking party. In this case, Truvine Landscaping, Mr. Cornwell is the undertaking party. The contracting party being Jacksonville Electric Authority and Cambridge at Oak Leaf Plantation being the contract. The contract was to maintain the grounds, the undertaking. Was to maintain the street lights in Clay Electric. In this case, it's to maintain the grounds, including monthly irrigation checks with any breaks to be reported to the property manager. And Mr. Cornwell himself testified that he fixes these things when he finds these. He replaces the sprinkler head when he finds one up. The nature of the service in Clay Electric was infrastructure maintenance affecting safety. And again, the same thing here, infrastructure maintenance that does affect safety. That was the nature of the service to be performed. The alleged negligence failed to maintain streetlights. The alleged negligence here is failed to properly inspect and maintain a sprinkler head, leaving that sprinkler head in an extended position so a pedestrian could trip over it, and again, failing to leave the road in darkness is what happened in Clay Electric. The injured party in Clay Electric, a third party, a little boy on a public road. He had no privity of the contract. Here, a third-party visitor to the property. The increased risk in Clay Electric, that was an increased risk of the darkness created an increased risk that a driver would not see a pedestrian. Here, the extended sprinkler head creates an increased risk of trip and fall. Procedural posture, summary judgment was reversed, and here we're looking at the same thing. Summary judgment was reversed in Clay Electric, and here we're looking at the same thing. Summary judgment in this one.
Counsel, you've exceeded your time, so if you want to just wrap up, then
Thank you, Your Honor.
I assume you want us to reverse.
I do want you to reverse the trial court's holding and remand this case for trial, please.
Okay.
Thank you.
All right. Thank you, counsel.
Here, but at the close of my business with the court, request permission.
Oh, yeah, yes, sir. Yes, sir. Thank you.
Good day.
Okay, we leave the world of sprinkler heads, and our second and final case this morning is case 24-1550. Joel, is it Gingery? Gingery? Okay, Joel Gingery, thank you, versus the state of Florida. All right, Mr. Offerman, whenever you're ready, sir, you may proceed. Just tell the marshal how much time you'd like on your rebuttal.
Good morning. May it please the court, Michael Offerman on behalf of the appellant Joel Gingery. I'd like to reserve 5 minutes of my time for rebuttal.
Thank you.
I intend to begin my argument this morning with the first claim raised in the briefs, and I'm also hoping to address the third claim, and then I'll answer any questions that the court has regarding the remaining claims. The first claim in this case concerns the trial court's error in overruling defense counsel's objection to the state admitting not only the audio of the controlled call, but also the video. Defense counsel below argued that, look, Judge, the only reason they want to get the video in is so that the jury can see the alleged victim crying during that controlled call. Now,
What's the difference between seeing her crying and hearing her cry?
Extremely different in this case.
How?
Because on the audio, you can hear her cry a little bit. And that's normal for the controlled calls that I've heard that have, as I said in my briefs, have only involved audios for the dozens of cases that I've reviewed, sexual assault cases that have controlled calls. But in this video, we have the alleged victim crying throughout the entire controlled call. And at times, she's crying uncontrollably. She has her head in her hands down while sitting on the couch for substantial periods of time. She is sitting next to a victim advocate who is consoling her the entire time with an arm around her, rubbing her shoulders. That image, and as I said, I've quoted from the Texas
Is the
Supreme...
jury entitled to view that in order to weigh the credibility of the accusations made and the basis of the call?
Absolutely not. Jury entitled to review a video of a controlled call?
Is it relevant to the credibility of the accusations?
No. So the detective in this case specifically said what the purpose of a controlled call is, and it's the purpose that I know the three of you as trial judges are aware, and you've heard hundreds of cases that I'm sure you presided over. The detective specifically said, we engage in controlled calls as a tool to try to get the accused to make a confession.
Sure.
Has nothing to do with the alleged victim being emotional and bolstering the credibility of the alleged victim. Now, that may come out, You might have controlled calls where the alleged victim is in fact emotional. In this case, if the audio had been played, the jury would have heard a little bit of crying. But to see her crying the entire time, and then more importantly, we don't have to speculate as to why the prosecutor wanted this in. Now, the judge, of course, said, and it wasn't really argued by the state, but the judge says the probative value of the video, because the objection specifically was, defense counsel says audio is okay, we're objecting to the video, and the judge overrules that and says the probative value of the video is it's probative of the fact that this was a controlled call. That's clear error. That's just clear error. It's not a material issue in this case as to whether or not this was a controlled call. Defense counsel was crystal clear that we concede that this is a controlled call. As I said, I've had dozens of controlled calls, and it's never been an issue where someone had to actually show the video to establish that it was a controlled setting where the call was taking place. Many controlled calls occurred in a park, in other places. They don't always occur in a law enforcement station. But going beyond that, the reason that we know why this prosecutor wanted the video to come in is in the closing argument, page 446. One of the factors you can look at is that the alleged victim, yes, she got very upset. You saw how upset she was here on the stand. You saw her demeanor. You saw that she was shaking. You saw her on the video when she was crying during the controlled call and how upset she was. I'd submit to you that someone who was lying couldn't think that for that long. The prosecutor is telling the jury, find him guilty, believe her, because you saw her crying on a controlled call video. Why did that come in?
Do you interpret that as an invitation to the jury to be swept away by the emotion of the call?
Yes, without question. This is a 403 case. And this is a poster case for what would be the prejudicial impact far outweighs any probative value when we're talking about just the video.
In the portion of the closing argument of the prosecutor you just read, did he reference she was emotional at the time of giving testimony in trial?
Sure, that's irrelevant. That's not the issue. That's not the point that was being made. Of course, alleged victims and other witnesses throughout trial proceedings may become emotional. Sometimes judges take breaks. The point that was being made here was she was crying at the time, the next day when the controlled call took place. That's why you should believe her, because she couldn't be lying for that long. You couldn't just make this up. But there's even another factor here in this case. Another
They made
factor.
that same argument based just on the audio of the controlled
But
call.
that's not what defense counsel argued. And I submit to you that the audio is nowhere near. So I quoted from the Texas Supreme Court that a picture is worth 1,000 words and a video is worth exponentially more. That's clearly the case here. It's one thing to hear her sniffling on the audio. It's far different to see her crying uncontrollably on the State's Exhibit 9, I know you've seen it, on the couch, victim advocate wrapped around her, hands on her head, while her head is buried in her hands, crying. There's no probative value of that, or to the extent that there is, it is far outweighed by the prejudicial impact. That is screaming for the jury to make
the unfairly prejudicial impact.
unfairly prejudicial impact. It's a
I know
403.
403 doesn't address prejudicial impact. It addresses unfairly prejudicial.
And this would be as unfair as it gets.
Okay.
The video was used to elicit sympathy, and we know it from the prosecutor's own words. And then there's another factor here. And this is why this becomes so dangerous. Maybe you've seen it in your other records. I have never seen the video of a controlled call played, and I've certainly never can imagine that a prosecutor would then get up in closing. And again, in this case, it's not only what I read to you, it's the very last thing in the rebuttal closing that the prosecutor played for the jury, and again said, the controlled call is what it is. That video is what it is. This prosecutor was really relying upon this video to make the point that believe her now because she was crying back then and she couldn't have been lying and still been crying a day later if this wasn't true. But there's more to the story, isn't there? We know that the victim coordinator told her prior to the controlled call, quote, all I need you to do is cry during the controlled call. Page 236. Defense counsel said it 3 separate times. Now, the judge made sure that portion was not shown to the jury. But wow, shouldn't we all step back and be concerned here that the state is manufacturing a situation for an alleged victim to cry so they can take a video of it, then show it to the jury, and then argue to the jury, believe her because she was still crying a day later after this incident. And she couldn't be lying and making that up and still be crying a day later. I'm offended when I saw this. This is one of the worst things I've ever seen in any of the cases I've worked on. The state of, again, there's evidence that comes out during these cases that other people come into contact with alleged victims after these sexual assault allegations. You might have someone, the sexual assault nurse, say at the hospital that, what was she like when you came into contact with her? She was distraught. Okay, the state can rely upon that. That's the fact. That's the truth. It's not manufacturing evidence. It's the way that it was. In this case, we actually have that. We have Brittany Bell, the mom of the alleged victim's best friend, who said that right after the incident, she called me and she was screaming. The jury got to hear that. The state can rely upon that and say, look, ladies and gentlemen of the jury, you heard from the best friend's mother who said that shortly after the incident, she reported it. Now, of course, the defense would come back and say, look, we got to see the surveillance videos from the hospital. We got to see her walking in at 10 o'clock. She looked excited to be walking in with him. We got to see her walk out at 10:45. He walked out with her. She wasn't distraught then. She wasn't crying. So it goes both ways. The defense certainly had an argument that, no, this was consensual sex, and after the fact, she's making this up. But wow, to create this video where the victim coordinator tells her you need to be crying, consoles her the entire time, and then that's played for the jury, and then highlighted not once but twice in closing argument with the specific argument, I'd submit to you that someone who was lying couldn't be crying like that on that video. That's unfair prejudice under 403. That's specifically eliciting to the sympathy of the jury. It's asking the jury to make a decision based on sympathy, based on an emotional response, rather than the facts of the case.
Well, let's talk about your third issue.
Florida law is what it is. And the state makes an argument that Justice Grimes in the Amos case, correctly, the state argues, points out that by the time Bova had been decided, or after Bova had been decided, the United States Supreme Court switched gears a little bit and said there's a difference between an overnight recess and a shorter recess in the middle of a trial. But the state's answer brief would have this court believe that somehow Justice Grimes was saying that Florida law, therefore, should be in line with federal law, but that's not what Justice Grimes is saying. And I'll quote from this is page 164 of the Amos opinion. He says, even acknowledging what happened in Perry following the Geters case, of course, under Bova, it is also impermissible to keep a testifying defendant away from counsel during a short recess. So Justice Grimes himself acknowledges that.
Well, he acknowledges what Bova holds. He doesn't necessarily express agreement with it, does he?
Yeah, I'm sorry. So let me, that's the point I was trying to make.
Okay.
He acknowledges in a dissent that Bova holds, and then Amos continues to hold, because he's in the dissent, that Florida law says that you cannot restrict a defendant from having access to counsel for any period of time.
And so I don't know that let me speak for myself. I don't know that I would disagree as to what Bova holds. I'm curious, Bova predates Perry from the United States Supreme Court. Perry seems to endeavor to address what is termed a shorter recess, whether that's 15 minutes, whether that's an hour, which Justice Grimes seemed to say that's more toward the Perry recess, perhaps. Right. I'm curious, does Bova then conflict with Perry? In other words, they seem to be two different outcomes on sufficiently similar circumstances.
Conflict if Bova is based only on U.S. constitutional law.
You're walking me right there. We sleep on the Florida Constitution entirely too often. I'm going to get there with you. But ultimately, would you agree that as it pertains to what the federal Constitution requires, Bova is different than Perry as announced by the U.S. Supreme Court?
Yes.
So my question is this: what is the origin? Judge Forrest in the Fourth, for whom I have considerable respect, makes a statement that his court, I believe, may have made previously in the Cadavid, I hope I'm pronouncing that correctly, the Cadavid case. He quotes Mears. Mears seems to rely on, if I recall correctly, a second DCA case. But
Leardman.
Yep. So it seems to suggest that the Florida Constitution provides greater protections than the federal Constitution. I'm curious the origin of that statement. I'm curious as to the basis, legal basis, for the statement of a district court of appeal in the state of Florida that the Florida Constitution provides greater protections than the federal.
Because Leardman says that in Bova, when the Florida Supreme Court made its ruling, it immediately it cited to both the Sixth Amendment and to the counterpart in our state constitution.
Would you concede there's nothing in the text, history, or structure of the Florida Constitution that compels that conclusion?
Yes.
Is there any binding precedent upon this court that mandates that conclusion? I understand.
Yes.
I understand. What is that?
That would be Amos. Because Amos continues following Perry to say, and Justice Grimes recognizes it, that under Florida law, as interpreted by the Florida Supreme Court, the defendant is entitled to consult with counsel regardless of how brief the recess is.
And let me articulate my question more precisely, and I don't want to get you into your rebuttal time. Amos does not declare expressly that the Florida Constitution grants greater protections. You agree with that? You concede that.
I concede that.
But by its holding, it provides that, is your point.
Yes. And I think every DCA that's ruled on it.
They're following Bova. I totally, listen, Perry changes Bova.
It does.
And let me be very clear with you. I'm not suggesting for even a moment that we are at liberty to disregard Florida Supreme Court precedent.
I know you wouldn't do that.
We happily, joyfully, willingly yield.
Of course.
That said, Perry and Bova are different. And now it becomes, what do we make of Amos, the Amos case, which is post-Perry, in the responsibilities we have in considering whether we are continue to be bound by Bova?
I agree completely, other than, again, despite all that, Justice Grimes still says, as I just quoted, under Florida law, that's his dissent in Amos, this is where we are, and this is what, in essence, you can read into that, this is what the majority is continuing to hold post-Perry.
And the trial in Amos that was, actually came up to this, that actually occurred after Perry.
Correct.
So, short period of time after Perry, and, not all, we're all trial judges before, so the fact that we didn't know something that was decided the week earlier by the Supreme Court, that's tough to pin on the trial judge, but chronologically, that's what has to be done.
When I clerked at the Florida Supreme Court, every time that occurred, I always dropped the footnote that said, at the time that this occurred, this was in the pipeline, and the trial judge would have had no idea that the change was occurring. That's true.
Your conclusion is Bova is determinative. Bova and Amos are determinative under both federal and Florida Constitution.
Amos, well, no, the only way my client wins on this claim is under the Florida Constitution. I acknowledge under the federal Constitution, the law has changed.
Okay.
Justice Grimes explains that. I think the state explains that in their answer brief, and that's true. We are waiting on what the U.S. Supreme Court's going to do in the Villarreal case.
They have an issue. They had oral argument. They haven't ruled yet.
That's it. I checked again this morning. They had oral argument, I believe, in October, and we are waiting on that ruling.
But that's an overnight recess.
I'm sorry, what's that?
That's an overnight
That
recess,
is an overnight.
is it not?
Correct.
That's very different than a 15-minute recess.
They may not provide more guidance to this particular issue, but they're at least considering the issue, and we'll see what they say.
Okay.
I see that I'm in my rebuttal time. I'll reserve the rest of my time. I, of course, hope that you don't reach that issue at all, because I think the first issue is so clear-cut, so prejudicial, and clearly not harmless for the jury to have seen that video, and then for the prosecutor to have it be the very last thing that's said to the jury.
But if we go on issue 3, and how you're arguing Amos is what Amos is, that would theoretically give the Supreme Court the chance to view that again in the context of,
It would be interesting, other than issue one clearly requires reversal.
all right, thank you, counsel. All right, Mr. Bradford, whenever you're ready, sir.
Good morning. My name is Robert Bradford. I represent the state of Florida in this matter. With respect to issue number one, Judge Dowd, I think you kind of hit the nail on the head. Not only was the video of the controlled call probative, it was necessary to the state's case in that the defense offered evidence that this was consensual sex and that the victim simply changed her mind, regretted it because she had slept with her best friend's boyfriend, and then apparently she started lying and saying that she was raped.
What's the time frame between the crime that the defendant was convicted of and when the controlled call was made?
I think it was the next day.
Okay.
When she presented at the hospital as suggested by her best friend, and I think her best friend and maybe the best friend's mother, she was emotional there too, right?
Yes.
To the extent, couldn't really talk to the triage nurse, had to hand the phone. to
As
the
I
triage
recall,
nurse.
that's
Okay.
correct.
Is that a
Same
right?
way
Is that
she
a?
was-
Go ahead. I'm sorry.
I was the same way she was upset on the phone when she first called.
Is that relevant to our evaluation of the prejudicial impact of the video of the control call?
I think it's all relevant. It's relevant because of the defense. Because if this 18-year-old girl had simply regretted sleeping with her best friend's boyfriend, would her crying be that extensive? That's the question. Can the jury reasonably infer that she was upset because she regretted her actions and it may cost her a friend, or would she regret it because she was forcibly raped? That's a completely different issue, and that I think makes it necessary, and why, even though it is prejudicial, it's not unfairly prejudicial.
What weight do we give to the state's instruction to cry on the video?
I think that is the jury's job to give weight to that evidence, and this court should not reweigh
Did
any
the
of
state
it.
instructed her to cry on the video? Or was that part left out?
I don't believe that was put before the jury. If it was, it doesn't matter. I mean, she's consoling. My argument on issue number one is two-part. One is I don't think they meet the abuse of discretion standard in that no reasonable person would hold in a manner that the trial court did. I think it's certainly subject to a difference of opinion.
Hold differently than what the trial judge did.
Yes, I'm sorry. My apologies. Yes.
There you go.
So
Kind of what Mr. Offerman's argument was. No reasonable judge.
I'm sorry, I've just been dealing with a handwritten pro se petition that speaks in double negatives for 60 pages. So anyway, so the probative value, I think, is clear, and because of the defense presented, it was not unfairly prejudicial. That is the significance of that point.
But his argument is the victim advocate, who I guess is an agent of the state, so to speak, is telling the alleged victim at the time, I know she became the victim after the conviction, but that make sure you cry. I mean, isn't that kind of disconcerting, for lack of a better?
If she had only cried during the control call, I think that might be.
No, to make sure you cry. If I don't want to misquote what Mr. Offerman was saying in oral argument, but that basically it was like, okay, you're on the control call, make sure you cry real hard here, or make sure you cry a lot so that it shows what it shows, I guess.
And I mean, that I would imagine would inure to the benefit of the defense, saying that it's all structured, that it's not real, that her tears are crocodile tears.
Did the jury hear that instruction?
I don't think they did. They may have, but I
Wouldn't it
I could
inure
be
to the,
wrong.
I'm sorry, I didn't mean to cut you, go ahead.
Just that if the state actors are telling the victim how to act, that I think could be argued to be that they're fabricating evidence.
Well, it would inure to Mr. Offerman's client's benefit if the victim was matter-of-fact, talk flat out, had no emotion. I mean, that would be more suggestive of his defense that this was a consensual act between adults. If, I'm crying, sobbing hysterically, or whatever term was being used, I'm not trying to put words in anybody's mouth, that suggests that this was something that I didn't want to have happen. I was the victim of a sexual battery, and that would be, I assume that's why the state wanted to present that evidence, because it supported their case, right?
And it opposed the defense. It neutralized the defense, which was she regretted it, not, and there's a difference. I think the state was trying to make a point that there's a difference between an 18-year-old who regrets having sex with her best friend's boyfriend and an 18-year-old who was forcibly raped.
Mr. Hoffman's argument is basically the victim advocate saying, make sure you cry real loud when you're on this controlled call. That
The issue is whether the video was admitted into evidence, not specifically whether the jury saw the state actor say, I need you to cry. That's not the issue here.
It's the video as a whole.
It's the video as a whole.
In other words, the point on appeal is not that the court erred in redacting that portion of the video. Make sure you cry.
No, that's not the issue as I recall it from the initial brief.
If I heard Mr. Ufferman correctly, that portion was redacted.
That's my understanding as well. The jury didn't hear that.
And I'm trying to recall the transcript. I'm trying to recall the record precisely. That's what I heard him. That's what I heard him say in argument. At some point, I'm curious to get to the third point on appeal. I'm curious as to whether or not we are bound by Bova and Amos.
Sure. The only other thing I wanted to say with respect to issue one was the harmless error argument. The fact, and I just don't see any difference if it's the crying that's a problem. I don't see how her crying, the jury heard that she cried when she called her friend's mother in Washington or wherever she was out on the West Coast. She cried during the control call. She cried during her testimony at trial. And again, this goes to the regret versus her lying.
What about the argument that she's credible because she cried during the controlled call, even though we told her to cry during the controlled call?
Again, the jury didn't hear, to my knowledge,
That's
that we
the problem,
told her
isn't it?
control. They didn't ask to put that in. They could have asked to put that in. They didn't. So I think we're stuck with those parameters, that it's just the video of what was shown to the jury that's being discussed here and what was objected to. But again, you know, if she's consoled several times, do you need water? Do you need to take a break? I mean, there's no rubbing of her back or anything, but she's crying. And I would disagree with my new friend's suggestion that you can barely hear her cry on the audio. I think it's clear. I think it was described in my answer brief exactly the extent, and I think he even copied that description in his reply brief. You could hear it. It was clear. It was clear how upset she was. Now, with respect to issue number 3.
Well, let's tee this up to some extent.
Yes, sir.
In Bova, as Judge Soud was referring to, we have Bova. Later on, then the U.S. Supreme Court in Perry rules what it rules on the Sixth Amendment, and then we have Amos. Now, the question then in Bova, and I'll just read it because it's what they wrote. The question presented for review is whether the constitutional right to counsel prohibits any restrictions on attorney-client consultation during a trial recess. I think that was a 15 or 10-minute break, I believe, in that case, and they eventually. But when they frame that question for their consideration, when they talk about the constitutional right to counsel, they cite both to the federal Constitution and to the state Constitution.
That is correct.
In footnote 2, you agree with that? All right, so at some point, the U.S. Supreme Court basically, it says in Perry, it's not a Sixth Amendment violation to prohibit, which that part you like, right? All right. So we still have the the Florida Constitution hanging out, and you know, the concern, and I think Judge Soud expressed it eloquently, is whether we like it or not, we have Amos. Certainly the Florida Supreme Court was aware in Amos of the decision in Perry. It was only a few years ago, and more to the point, their colleague talked about it in his partial dissent. That didn't seem to move the Amos court to step away from Bova and say, well, 15 minutes, you can't have a consultation during 15 minutes on either the federal or the Florida Constitution. Do you agree that's the lay of the land? I mean, I know you argue what you argue, and you certainly have 10 minutes to talk about it, but
I think.
that's the
under-
lay of the land that we're looking
under
at.
Florida law, there's no, you can't have no restrictions, and.
Under the Florida Constitution, apparently.
apparently.
I mean, the federal Constitution, and in fact, I think Justice Grimes even mentioned in his partial dissent, he said, well, under federal law, that's, you know,
Yeah, he cited
that's by the
period
wayside,
and
yeah.
distinction.
There was no error under federal law, specifically what Justice Grimes wrote in his partial dissent. I mean, he thought it was harmless error because Mr. Amos, on his, I guess it was his 5th trial, he's clearly guilty, and I guess that was his extrapolation of the harmless error test. But he said it was harmless error there, and so under that aspect of the case, he said, well, you know.
Yeah, Your Honor, I went back, the Bove Court cited to, of course, Getters, and it also cited to a state case named Style Stripling, which actually was a 2-hour lunch recess that was taken between direct and cross. All of these seem to fit during direct and cross. Almost.
We're having a unique scenario in the courts about 10 minutes, 15 minutes, hour, 17 hours overnight. Apparently, the constitutional right varies depending upon the clock.
And I think that brings up a good point in this case, because I think the original recess was for 15 minutes, but then they addressed a couple of matters after the jury left, and so then they were going to take, so that was maybe 10 minutes or so. And so they only had about 5 minutes left, and then they took a comfort break, and that's when he announced, don't talk to your attorney. So this is even a smaller recess than in any case I've ever seen, which is 5. And I think it's important to remember that when you're talking about, you know, to recognize the distinction between Getters at the overnight or a big 2-hour lunch break or whatever, when you can sit down and strategize and talk way more about things than just the defendant's testimony. Whereas if you've got 10 minutes, 5 minutes, 15 minutes, there's almost a presumption that's what you're going to testify to. And in this brief, that's exactly what he says. He wanted to coach him on how to say these things without getting a hearsay.
And that calls into question the integrity of the evidence presented.
Exactly.
I understand that.
It's a truth-finding process. I understand the defendant's rights, but the whole thing is designed to find the truth. And if you start overcoming cross-examination, which is a component of the truth-finding process, if you start chilling the effect of cross-examination by letting him speak to his attorney about his testimony and how I can better say it and get my point across, that's I think too much of a compliment.
Listen, the ink flows from the pen pretty fluidly on that issue, in my view. And yet, Amos. And yet, Bova. In other words, Amos, I think, was an hour-long recess. And let me say this. I understand the notion of the peculiarity of now we're talking about the right to counsel with a 10-minute recess, 15-minute recess, hour-long recess, 2-hour recess, overnight recess. I understand that. But directly to your point, it is entirely about what it is counsel's going to be able to discuss during the duration of the recess.
Exactly.
You can talk about trial strategies and other matters beyond cross-examination with a longer recess. Every trial judge knows if you have a 5-10-minute recess, there's barely time to talk about much in the courtroom. And for defense counsel to go to a holding cell area if the defendant's in custody, you really have no opportunity to talk about anything else.
Exactly.
And how often then are we going to invite defendants to claim a need for a recess in the midst of after a direct, before a cross, for final instructions and guidance on cross? I hear all of that. What do we do with Amos? Amos is an hour. Maybe it's factually distinguishable. Maybe Perry speaks, but we still have Bova referencing the Florida Constitution, and Bova and Amos, does that bind this court from the Attorney General's perspective? We're not at liberty to disregard it. We do not want to disregard it if it binds us.
I can't argue that this court is not bound. It is. I think it is. I think it has options on what to do to, maybe represent this to the Supreme Court and have them take a second look at it in light of Perry. What's important is in the case of Traylor versus State, the Supreme Court talked about construing the Florida State Constitution Bill of Rights, for lack of a better word, Article 1, Section 16. And it says that they should focus primarily on factors that inhere to the own unique state experience. This is the express language of the constitutional provision, its formative history, developing state law, evolving customs, traditions, and attitudes, et cetera, et cetera. And then finally, any external influences that may have impacted state law. That would be getters.
Well, let me ask,
So,
I mean,
and one more thing, if I may, Your Honor.
yes, sir, go ahead.
With respect to this particular court, in Peoples versus State, this court in 1991 found that the language used in the Florida Constitution to be heard in person by counsel or by self or both provides no stronger rights than the Sixth Amendment to the U.S. Constitution. Now, that was not an access to counsel case, that was a right to counsel case. But still, this court interpreted that language.
You know, in Bova and in Amos, with Bova creating this concept that we're dealing with today, they both ended up finding it was harmless error.
Yes.
Is that in your view, a viable scenario here?
Absolutely.
Did you raise that in your brief?
No, I did not.
Well, let me ask, we're not precluded from independently doing a harmless error analysis, are we?
I would suggest that you're bound to under state law.
Well, I mean, I was just throwing the chum out here because there actually is there's a Florida Supreme Court case, Heuss, H-E-U-S-S, that says the question of the case is whether or not an appellate court may engage sua sponte in a harmless error analysis, and the court said yes, and I think there's subsequent cases that suggest that we're obligated to. But at the very least, we can sua sponte do it, because that was the clear question that was asked in Heuss 30 years ago.
I think you can do it sua sponte, but
Let's say we do that in part of our overall analysis in this interesting case. So why would this be harmless error in the sense that this is kind of there's not a lot of dispute about the physical evidence. This is a he said, she said. So doesn't that make it more likely not to be harmless error?
Well, I think if you consider the objections during his direct testimony and his redirect testimony, there were, as I counted, about 24 different hearsay objections. Several of them were based on the questions themselves. What was the agreement? What did she say next? I mean, they expressly called for a hearsay answer. Sometimes they were talking about the specific acts. I asked her to whatever. She said, wait, do this, whatever. I mean, it was not, it was about topics.
They had a different view of what happened.
Well, of course,
yeah.
but my point being is that the materiality of all of these topics is not important. He was either able to rephrase the questions or the answers, or there were no, I think maybe one motion to strike. I mean, the jury certainly heard these answers, but the importance is
it's harmless because whatever the consultation that was precluded, Mr. Defendant ended up getting his testimony the way his consultation would have directed him, or helped, not directed, no coaching, no direct, would have, under advice, would have formulated in that direction?
I have two responses to that, Your Honor. One is that he was able to put before the jury his entire defense, that he was cheating on his girlfriend with the victim. He lost his jiu-jitsu school because of it, that they had a signal worked out where they would how to meet and how not to get caught, considering his schedule and his girlfriend's searching his phone, and the fact he was able to get the fact that she actually initiated physical contact that night in the call room by hugging him and kissing him. He was able to testify that she did not fight him off in any way as they were having sex, and that she was flirting and smiling and waving at him as he sneaked her out of the hospital, or snuck her out of the hospital.
Well,
So there's no reasonable possibility. He got his complete defense. And so therefore, I do believe it was harmless error. And if Your Honor, this is the most important thing. Not once, but twice during his testimony, he was instructed by the court to stop saying what people told him and to say only what they did.
Well,
His counsel also told him twice in the courtroom on the record, What possibly could counsel have said to him in private that would have made any difference? The judge, the second time, I mean, the first time he was just very plainly, you can't, after you did it 2 or 3 times, you can't say what people said. And then later on, you could see the judge was getting a little frustrated. And he said, do you have a question about the fact that you're not supposed to say what people said to you? Obviously getting a little snarky because he kept doing it so much. But the bottom line is, if that didn't convince him, he couldn't say things that people told him, what possibly could defense counsel have told him in those 5 minutes?
Well, since we're speculating, since we're kind of chewing the fat over the Amos, the harmless error test, explain that to me under DiGiulio. I mean, it's you can't
no
look at
reasonable-
you can't look at the weight of the evidence, overwhelmingness, et cetera. It's whether it would have whether it would
There's
affect.
no reasonable possibility that it affected the verdict.
Well, isn't that based upon the evidence?
Well, it is based upon.
I mean, I know somebody's got to write something to explain how it's harmless error. I've always been interested in saying, okay, it's not the sufficiency of the evidence, the weight of the evidence, the overwhelming evidence, it's that long.
It wasn't
Descriptive paragraph.
unfairly prejudicial. I mean, I'm sorry. It just,
Maybe when Judge Saud's writing about this, he'll say, not only don't I like Amos, I'm not too big of a fan of DiGiulio either. But, I'm just pulling your leg.
the bottom line is, he got his complete defense out in front of the jury. They heard it. So it didn't.
Okay. Thank you, counsel.
Thank you, Your Honor. We would ask, the state would ask for the judgment and sentence to be affirmed in all respects. Thank you.
I figured.
May it please the court. I'm going to
Did you help
quickly.
write that back in 1986, the harmless error test, or was that before your time?
That was before my time. I was
All right.
97 to 02.
All right, go ahead.
Quickly on harmless error, and then I do want to jump back into claim 1. It's not harmless because potentially the most damaging thing that came out during cross-examination was this, you've had 19 months to come up with your answer. And clearly had one of the things you could imagine that defense counsel would have said, okay, we're getting ready to go on the cross. They go at you for what you're getting ready to say. You come back and say, I may have had 19 months, but what I'm saying today is the truth. But no, he did not have a chance to say any of that. He was kind of caught flat-footed with that question, and the state can't prove beyond a reasonable doubt that had there been consultation, that my client may have done a better job with that answer.
But play that out just a minute. I would imagine, would there be an opportunity? Of course, I never allowed to recross, but you had a chance to talk to your lawyer during the course of this 5-minute recess, didn't you? If recross would be allowed. I mean, there's a lot of ways that this can play out. I'm curious as to your best argument as to how your client was harmed by being precluded from talking to his counsel during the 5-minute recess.
I just gave it to you.
Yeah, and I think you did. But if I understood the briefs correctly, part of the argument is he could have helped him avoid this repetitive hearsay issue.
I don't want to focus on that as much because I think some of that did occur before the request to consult with counsel even happened. So that's why I'm sticking with the point I just made.
Okay.
I have a minute left. Don't fall down this slippery slope of allowing videos to come in these cases. This is an adult. It's not a child hearsay case. In child hearsay cases, there's an exception the legislature has made. The jury gets to see the video of the child. That's not a dispute here today. I'm not going to argue that. But for adult cases, we generally allow the adult's accusation to be what's said on the stand, and that's what the jury relies upon. We could imagine situations that this is now going to set the slippery slope where, okay, when you come in to meet with the detective, let's record you as you're coming in. You're crying. When you go in to meet with the sexual assault nurse, let's record you. It's one thing for the nurse to say, she was distraught. But now we're going to, in every case, get a recording of you crying. Because everyone knows it's logical, it's far more powerful to see the person crying. And that's why the prosecutor said in closing argument, you saw her on the video when she was crying. Not you heard her, you saw her. This video should not have come in. The judge said it came in because it showed it was a controlled environment. No one's defended that. That's a ludicrous ruling. That's error. The video should not have come in, and my client didn't get a fair trial because of it. Thank you.
All right. Thank you, counsel. Interesting argument. All right. Gentlemen, we will take it under advisement. We stand adjourned. Have safe trips back to...
Good seeing you. You too. Yes.